Wesley McMillan.
Thank you, Chief Justice and Justices. If a legal right is at play, it is justiciable. Justiciability is not a second stage analysis to avoid the court's obligation to resolve legal disputes. The example of employment was brought up in the appellant's presentation. If an employee's contract incorporates doctrinal issues, the court cannot simply choose to not resolve the underlying employment issue. If, for example, continued employment is contingent upon adherence to the faith or an aspect thereof, the court cannot refuse to intervene when there is a dispute over the termination of that employment. Of course, the remedy would be limited to damages, and thus this example does not risk the court directing a church or religion as to what it must do or not do. Church property cases are different. Church property cases are the best and perhaps most frequent example of court intervention in religious disputes. They are, in essence, membership disputes. One group claims to be the true adherents of a faith, and that another group are not or are no longer adherents of the faith. And courts have been careful to attempt to resolve those cases without addressing doctrinal matters. One approach, where available, is to consider whether the church is able to alter its doctrine, and that's the Free Church of Scotland decision, and subsequent decisions dealing with the Anglican Church's stance with respect to same-sex marriage. Another approach is to engage in an interpretive analysis as to who is the beneficiary of the trust, and that was done by the Ontario Court of Appeal in Tewahedo. But some cases are not so simple, and it will of course depend on the terms of the trust. A trust may be on terms that the church continue to follow a particular scripture or religious belief. For example, a trust may be on terms that the church follow the requirements of Matthew 18:15 or recognize the sanctity of marriage. That may be resolved by a determination as to who has the final say on doctrine. But to suggest that it is not judicial intervention in purely religious matters is simply not correct. A decision as to who gets to decide a religious faith's doctrines is by its very nature purely religious. Yet to resolve the trust dispute, the underlying legal issue, the court must act. To the extent that scripture or doctrine is not put in tangible or secular terms, the court must wade into religious matters. This is so because a secular legal right is at issue. The court cannot abdicate its responsibility. And in my submission, concerns about justiciability have no role where there is an underlying legal right in issue. Now, to address the issue of an underlying legal right, I want to take it out of the religious context. And I mentioned the Alberta Court of Appeal decision in McCarger in my factum. And the concern that arises from there is that McCarger seems to be saying that a member has no standing to challenge the vires of an incorporated society's actions and decisions. And incorporated societies have a leadership group, a board or executive, and there's a constitution or bylaws that govern the organization. And in McCarger, the Alberta Court of Appeal said that a member has no ability to challenge the actions or decisions of the board. And this court ought to clarify when members have standing to challenge organizational decisions, particularly incorporated organizations. When does membership create a contract or provide a member a right to challenge organizational decisions? When can a member bring a claim that an action or decision of the organization is contrary to its bylaws or constitution? And the concern with McCarger is that the court seems to be saying that unless membership contains express contractual language, a member never has the ability to challenge organizational decisions. And that relegates the organization's constitution and bylaws to merely aspirational documents rather than governing documents. If not a member, who enforces compliance with the constitution and bylaws? And any suggestion that a member can simply quit the organization trivializes the relationship between a member and that organization and gives carte blanche to the leadership of the day to reimagine the organization in any way it wishes without regard to its constitution or bylaws. Thus, membership decisions must also be reviewable by a court. If they are not, the leadership can simply eject those members with whom it disagrees and proceed to ignore its constitution and bylaws with full knowledge that nobody who would object has standing to challenge its actions and decisions. Subject to questions, those are my submissions.
Thank you very much.